Hello, everyone, and welcome to Uncivil Law. By request, we are covering Tennessee versus Lane, a 2004 Supreme Court opinion that deals with the applicability of the Americans with Disability Act as it applies to local and state governments, particularly as it relates to courthouses. There was some allegations made that people were being denied access to courthouses because lack of facilities for the disabled. So the Supreme Court is trying to decide whether or not the federal law of the Americans with Disabilities Act can apply to states or whether or not is in excess of constitutional power from the federal Congress to do this. Let's get started with this. Title II of the Americans with Disability Act provides that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of services, programs, or activities of a public entity or be subject to discrimination by any such entity. The question presented in this case is whether Title II, which recites what we just said, exceeds Congress's power under Section 5 of the 14th Amendment. So the 14th Amendment grants equal protection, and Section 5 allows the Congress to provide regulations around that, to provide statutes that help to enforce that. So the question is, can Congress legislate this particular thing under this authority of Section 5 of the 14th Amendment? So if they're trying to provide equal protection, can they use Section 5 that says Congress can legislate in this domain? Is that a valid power, or is it going too far in this particular context? The respondents, both of whom are paraplegics who use wheelchairs for mobility, claim they were denied access to and the services of state court systems by reasons of their disability. Lane alleges that he was compelled to answer for a set of criminal charges by appearing on the second floor of a county courthouse that had no elevator. At his first appearance, Lane crawled up 2 flights of stairs to get into the courtroom. When Lane returned to the courthouse for a hearing, he refused again to crawl up the stairs or to be carried by officers to the courtroom. He consequently was arrested and jailed for failure to appear. Jones, a certified court reporter, alleged that she has not been able to get access to a number of county courthouses, and as a result has lost both work and opportunities to participate in the judicial process. Both of these respondents seek damages and equal relief. So both of these individuals are trying to appear in various courthouses that don't have elevators, and they're paraplegic, and so, that's a bit of a problem. And they're trying to figure out whether or not the federal Congress can regulate around this area. The state moved to dismiss this on the grounds that was barred by the 11th Amendment. All right, so the 11th Amendment generally prohibits suits from citizens of other states on its own terms, and it has been interpreted to prohibit suits against the state by citizens of the own state. So you have to find some other authority to specifically allow for this. So you can't sue in federal court. You can sue in state court, but not in federal court. So the idea here is separate sovereigns. So if you have a complaint against the state government, you can sue in the state government. If you want to sue in this federal government, you want to sue in federal courts, you need some sort of federal hook. You can't just sue them generally. They generally are not able to be sued in federal court unless there's a specific statute granting authority. So that's the 11th Amendment, or at least how it's been interpreted. In a case called Garrett, we concluded that the 11th Amendment bars private suits seeking money damages for state violations of Title I of the Americans with Disability Act. We left open, however, the question as to whether the 11th Amendment permits suits for money damages under Title II. So we said Title I, not so much, but this is Title II, so let's figure that out. The Americans with Disabilities Act was passed by large majorities in both the houses of Congress after decades of deliberation and investigation onto the need of comprehensive legislation to address discrimination for peoples with disability. Invoking the sweep of congressional authority, including the power to enforce the 14th Amendment and to regulate interstate commerce, because of course, why not? The Americans with Disability Act is designed to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities. It forbids discrimination against persons with disabilities in 3 major areas of life: employment, which is covered by Title I of the statute; public services, programs, and activities, which are covered by Title II; and public accommodations, which are covered by Title III. So if you are being discriminated against because of your employer, that's Title I. If you're being discriminated because a business won't give you, it won't let you do business there because of disability, that's Title III. So Title III is directed at private enterprises. And then in the middle, we have Public II, which is why we're here, the program, services, and activities of the government. Title II prohibits any public entity from discriminating against a qualified person with disability in the provision of the operation of public services, programs, or activities. And the term qualified here just is defining what a disability is. So not all disabilities qualify. The thing that makes you qualified is that you have a qualifying disability. So yeah, that's what it means by qualified. The Act defines the term public entity to include state and local governments, as well as agencies and instrumentalities. So if you are a person that is under the auspices and protection of the statute, you're qualified, and then that applies to state and local governments and agencies and so forth, so it would obviously apply to courthouses. The 11th Amendment renders the state immune from any suit in law or equity commenced or prosecuted by citizens of another state or by citizens or subjects of any foreign state. Even though the amendment by its terms applies to suits only against citizens of from another state, our cases have repeatedly held this immunity also applies to uncontested suits brought by a state's own citizens, under the idea of sovereign immunity and sovereign jurisdiction. Our cases also held that Congress may abrogate the state's 11th Amendment immunity. To determine whether Congress has done this, we must resolve two predicate questions. First, whether Congress unequivocally expressed intent to abrogate the immunity, and second, if it did, whether Congress acted pursuant to a valid grant of authority. So can Congress do this, and did Congress do this? The first question is easy enough in this particular case. The Act specifically provides that a state shall not be immune under the 11th Amendment to the Constitution of the United States from an action in federal or state court of competent jurisdiction for violation of this chapter. So did Congress abrogate the immunity? Yeah, they're kind of pretty clear on that. The question then is whether or not Congress has the power to do this in this instance. In a prior case, we held that Congress can abrogate a state's sovereign immunity when it does so pursuant to a valid exercise of power under Section 5 of the 14th Amendment to enforce the substantive guarantees of the amendment. So if the Congress is trying to promote equal protection, they can, in general, use Section 5 of the 14th Amendment, although there are limits. Section 5's power is not unlimited. While Congress must have a wide berth in devising appropriate remedial and preventive measures for unconstitutional action, those measures may not work to be a substantive change in the governing law. Section 5 legislation is valid if it exhibits a congruence and proportionality between the injury to be prevented or a remedy and the means adopted towards that end. In a prior case, we held that Congress exceeded its Section 5 authority when it enacted the Religious Freedom Restoration Act. So there have been cases that have struck down things that Congress has tried to do, including the Religious Freedom Restoration Act, which was an act passed by Congress. I think it might have had one dissenting vote in the Senate. Otherwise, it was unanimous. But basically said that, you have to have strict scrutiny when it comes to religion. And they tried to say this to the states. And the court said, no, you can't do that. That goes too far under Section 5 of the 14th Amendment. So the Religious Freedom Restoration Act still applies to the federal government and federal action. Many states have state-level equivalents, but that was one example where it was strict down as not being a valid exercise of the Constitution's 14th Amendment power to create legislation. Applying the prior case law, we've concluded that Title I of the Americans with Disability Act was now a valid exercise of the power to enforce the 14th Amendment prohibition on unconstitutional disability discrimination in the public employment arena. Okay, so we have previously held that this is not sufficient when it comes to employment issues, but of course we're under a different section of the Americans with Disability Act as it applies to public accommodation. So the government, when it is doing things in an employment context, can act more as a private employer, and this doesn't bind them on the state level. But how about as it relates to the public accommodation? What is the standard there? So to figure that out, we have to go read the relevant constitutional guidelines that apply. The first step of the inquiry requires us to identify the constitutional right or rights that Congress sought to enforce when it enacted the law. As we have observed, classifications based on disability violate the constitutional command if they lack a rational relationship to a legitimate governmental purpose. Title II, like Title I, seeks to enforce the prohibition on a rational disability discrimination, but it also seeks to enforce a variety of other constitutional guarantees, infringements of which are subject to a more searching review. With respect to the particular services at issue in this case, Congress learned that many individuals in many states across the country were being excluded from courthouses and court proceedings by reasons of disability. A report before Congress showed that some 76% of public services and programs housed in state-owned buildings were inaccessible and unusable by persons with disabilities, even taking into account the possibility the services and programs might be restructured or located to other parts of the building. Given the sheer volume of evidence demonstrating the nature and extent of the unconstitutional discrimination against persons with disability in the provision of public services, the dissent's contention that the record is insufficient to justify this exercise of power is puzzling. Just as in last term we approved the family care leave portion of the Family Medical Leave Act as a valid legislative purpose based primarily on evidence of disparate provision of parental leave, little of which concerned unconstitutional conduct. So we have previously held that the state can be held responsible to this, and we've done so in other cases, and this is no different, says the majority opinion. The conclusion that Congress drew from the body of evidence is set forth in the text of the ADA. Discrimination against individuals with disabilities persists in such critical areas as education, transportation, communication, recreation, institutionalization, health services, voting, and access to public services. The only question that remains is whether Title II is an appropriate response to this history of treatment. So the court here is distinguishing between the reasons that Congress might want to do this and its power to do this. So did Congress have reasons to do this? The court says yes, it had reasons. It did studies, it did some analysis. It said, yeah, there were valid reasons. The majority is like, we're not quite sure what the minority was thinking, but there seems to be more than enough here as reasons. But that, of course, doesn't mean that what Congress is doing is constitutionally valid. So to figure out whether it's constitutionally valid, we have to figure out what is the source of power and does it apply in this particular context. At the outset, we must determine the scope of the inquiry. What exactly is the question we're asking? That's a good one to ask. Title II, unlike the Religious Freedom Restoration Act, the Patent Remedy Act, and other statutes we've reviewed for validity under Section 5, reaches a wide array of official conduct in an effort to enforce equally wide range of constitutional guarantees. Nothing in our case law requires us to consider Title II, with its wide variety of applications, as an undifferentiated whole. So just because it might be invalid for some purposes doesn't mean it's invalid for all purposes. Congress's chosen remedy for the pattern of exclusion and discrimination described above, Title II's requirement for program accessibility, is congruent and proportional to the object of enforcing the right of access to the courts. The remedy that Congress chose is nevertheless limited. Recognizing the failure to accommodate persons with disability will often have the same practical effect as an outright exclusion, Congress required the states to take reasonable measures to remove architectural and other barriers to accessibility. The statute only requires reasonable modifications that would not fundamentally alter the nature of the services provided, and only when the individual seeking modification is otherwise eligible for the service. As Title II's implementing regulation made clear, the reasonable modification requirement can be satisfied in a number of ways. In cases of facilities built or altered after 1992, the regulations require compliance with specific architectural accessibility standards. So anything built after 1992 is subject to the law's definition. But in the case of older facilities, which structural change is more difficult, a public entity may comply with Title II by adopting a variety of loss causality measures, including relocating services to the alternative accessible sites and assigning aids to assist persons with disability and services. So there is a wide range of things that the state or local government can do to provide the accommodation, not necessarily modifying the building is necessarily required. The duty to accommodate is perfectly consistent with the well-established due process principle that, within the limits of practicality, a state must afford all individuals a meaningful opportunity to be heard in its courts. For these reasons, we conclude that Title II, as it applies to the class of cases implicating fundamental rights of access to courts, constitutes a valid exercise of the Section 5 of the 14th Amendment authority to enforce the guarantees. The judgment of the Court of Appeals is therefore affirmed. So that brings us to the end of our discussion of Tennessee versus Lane. In this case, the federal Supreme Court deals with the applicability of the Americans with Disability Act as it applies to state and local governments, particularly courthouses. The Supreme Court rules that the Congress had sufficient reasons to enact it and that this was a valid use of the Section 5 power. Not all uses are valid, as the court has noted, but this was in keeping with a valid purpose to ensure equal protection under law. So states have to provide reasonable accommodations to courthouses. This does not necessarily require them to alter the building. They may be able to accommodate in other ways, but they still have to provide access so that everyone can get access to the courts. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.